सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen तो.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
A parliament session in a democracy is a gift that keeps on giving. How many times do we fret over the fact that our parliament doesn't function, our parliament has noise, people are supposed to make laws, hundreds of crores are wasted on maintaining them, on their housing, on their salaries, and yet no business gets done in parliament. But when business gets done, as we saw over the last few days in the course of the no confidence motion debate, then almost every 5 minutes, it does something, it gives you something that adds to your knowledge or that adds to the debate or that gives you something to talk about, analyze, discuss or take forward. In the last hours of this parliament session, after the no confidence motion was over, Modi government came up with more such gifts. Not nice gifts for prospective criminals, but gifts nevertheless for journalists because there is so much to talk about. Gifts also for lawyers, but gifts I'm particularly concerned about journalists because this is a set of new laws. This is a set of three fundamental laws. Three fundamental laws in any criminal justice system are the Penal Code, the country's Penal Code, the country's Code of Criminal Procedure, and the Evidence Act. So India had inherited from the British these three laws, the Indian Penal Code, IPC, then CrPC, Criminal Procedure Code, and then the Indian Evidence Act. These three will now be replaced by three new laws. These three new laws were moved in Parliament today. While moving them, Home Minister Amit Shah said that these will now be sent to the Standing Committee of Parliament because these are really major laws, major new laws. IPC, for example, has been there since 1860. In fact, even the Penal Code in Pakistan is pretty much a mirror image of this IPC because both countries inherited it from the British. Since then, much has changed. The nature of crime has changed. The nature of criminals has changed. The tolerance towards certain crimes of our society has changed. Many things have happened. So that has changed. Three new laws which were put forward today, which were put on the table of the House today. These three laws, these have Hindi names. So IPC, which was Indian Penal Code, now becomes Bharatiya Nyaya Sanhita. CrPC, Code of Criminal Procedure, now becomes Bharatiya Nagarik Suraksha Sanhita. And the third one, Indian Evidence Act, now becomes Bharatiya Sakshya Bill. Now, we haven't had the time to read up all of these because these are really major laws. So maybe going ahead, we'll talk about each one of these in some detail. But today, let me focus on only a couple of things, all linked to the former Indian Penal Code and its new avatar, the Bharatiya Nyaya Sanhita. The issues that I'm particularly looking at, first of all, is sedition. That's been a very contentious issue. Number two, terrorism, again something which needed sharper definition. Modi government in the new law has actually given it a very detailed definition. Then assaults, crimes against women, crimes against children, and assaults against human body, organized crime, all of these have been codified in the new version or the new avatar of the Indian Penal Code, Bharatiya Nyaya Sanhita. So see first of all the change in the sedition law. The old sedition law was 124A. All of us have written an editorial saying how bad it is that a law that the British made to protect their government, because 124A, under that law, sedition was a crime against the government of the day. That's why the Hindi translation was more apt. It was Rajdroh. Whereas a rebellion against the country or something, an act that does damage to the country is Deshdroh. What the Modi government has now done is, in the new law, they have abolished, they've repealed 124A because in any case, this IPC will be repealed and nothing will replace the sedition law. Sedition will not be a crime anymore, but a lot of the things which were earlier swept into the sedition bucket will now go into the kind of treason bucket. So what used to be Rajdroh will mostly now become Deshdroh. And it's very difficult, much more difficult morally to argue with a charge of Deshdroh, with the charge of treason, with the charge of damaging the nation. That's very different from damage the government of the day. The new section now in the new law, Bharatiya Nyaya Sanhita, is section 150. The old law spoke about exciting or attempting to excite disaffection towards the government, and punishment was 3 years to life imprisonment. New law talks about acts endangering sovereignty, unity and integrity of India. It doesn't use the word sedition. It talks about any words. Now, this is very important. It's not just actions, also words. It talks about any words, either spoken or written or signs or visible representation. Somebody puts up a signboard or a hoarding or visible representation or electronic communication or financial means or otherwise, which means somebody paying money to what is seen to be a subversive organization, right? That will also bring in the charge of Deshdroh in this case, the charge of treason in this case. So actually, while sedition is out, what's come back is sedition raised to the power 3, because even morally, it's one thing to defend the charge of rebelling against your government. It's quite another to defend the charge of rebelling against your nation. That is the biggest change, biggest transition from the old law to the new law. So while on the one hand, the Home Minister said quite proudly that sedition is gone, it is a colonial-era law. The British had brought in this law to protect themselves, their government. The fact is that what's come in is actually quite formidable. Also, the punishment for this offense goes up. It was 3 years to life imprisonment earlier. Now the minimum punishment is 7 years. That is again a sizable change. Again, the offense of waging war or attempt to wage war against the nation. Government of India now has been empowered under this law to seek extradition of a person sitting outside India, plotting to commit the crime. That is a lot of people from the Sikh radical groups sitting in Canada, Britain. This will particularly affect them. I don't think anybody sitting in Pakistan is going to bother so much about that, but anybody sitting in freer countries is going to worry about that. Again, there is an amendment to the law whereby somebody accused of a crime in India, a serious crime in India, can be tried in absentia. Now the person doesn't have to be present, can be tried in absentia, can be given a punishment, can be sentenced in absentia. Of course, you can't send a person to jail or hang a person in absentia, but while the person is overseas, the person will carry a sentence on their names. And then the only way, if they want to appeal against the sentence, the only way they can do it is if they come back to India, they surrender to Indian law, and then they seek a reprieve from law. They cannot do it remotely. They cannot do it from another country. That is again a major change in these laws. There is a new provision again, very significant. There is a new provision that defines sharply the terrorist act. Now, my colleague Bhadra Sinha, who heads our legal and judicial section, in fact, a lot of the analysis I'm giving you has come thanks to her, because she's read this and she's reported on this, and I have picked her brains. So she points out to me that the other really important change is that the law now, the penal code, the new penal code defines a terrorist act. So that wasn't the case earlier. Earlier, the definition often came from the UAPA, Unlawful Activities Prevention Act. Now, while trying those cases, particularly bail applications of those arrested post Shaheen Bagh protests in Delhi, including Asif Tanha, Natasha Narwal and Devangna Kalita, while giving their bail order, Delhi High Court judges had pointed out lacunae in UAPA, where they said there is lack of clear definition of what is a terrorist act. So now the new section 111 in Bharatiya Nyaya Sanhita, that tells us that number one, a person is said to have committed a terrorist act if he commits. Law still says he commits. Nobody says he/she. So our governments, our establishments still don't worry so much about the pronoun business. So if he commits any act in India or in any foreign country with the intention to threaten the unity, integrity and security of India, to intimidate the general public or a segment, or to disturb public order by doing an act. And then it goes on to say using bombs, dynamite, other explosives, etc., causing death, bodily harm, And then it also adds that terrorism can also be destruction of property. Now, UAPA also talks about destruction of property. This new law specifies property public or private, but it also says it adds a new feature, which is obstructing supplies. So it is not just destruction of property, it is also obstructing supplies. That also becomes a terrorist act. And this is important. This is important because the sedition law has been abolished. That's why you must listen to this. This is important. This is subclause 4 under new section 111. It says to provoke or influence by intimidation the government or its organization in such a manner so as to cause or likely to cause death or injury to any public functionary or any person, or an act of detaining any person and threatening to kill or injure such person in order to compel the government to do or abstain from doing any act, or destabilize or destroy the political, economic and social structures of the country, or to create a public emergency or undermine public safety. Now when you listen to all this, you should keep in mind one line that the Prime Minister used in his speech. He said, while accusing the opposition of being aligned or being soft on separatists, on the tukde people as the BJP calls them, he said that somebody said, he made a reference to somebody. That somebody was actually Sharjeel Imam. To somebody who said that look at Siliguri, it's a very narrow corridor with which the Northeast is joined with India. If you get a bunch of people and you can block this corridor, you can cut off the Northeast from India. So he made a reference to that. Now today, even a call to do something like that, as I understand the new law, will be seen as a terrorist act or an instigation to terrorism, which is the same now as a terrorist act. So once again, forget this sedition law. You've now got serious stuff, and this law means serious business. In fact, if I go back to what Sharjeel Imam said, Sharjeel Imam spoke in early 2020 and he said, matlab, itna mawad dalo patriyon pe, create so much mess, throw so much debris on the railway tracks, रोड पे कि उनको हटाने में एक आध महीना लग जाए. Put so much debris on the highways and on the railway tracks, it may take them 1 or 2 months just to remove that. असम को काटना हमारी जिम्मेदारी है. It is our responsibility to cut off Assam. असम और इंडिया कट के अलग हो जाए, तब ये हमारी बात सुनेंगे. Only when Assam and India are separated physically like this will they listen to us. Now, you might say, somebody might say this was just an irresponsible statement. After all, what wherewithal did he have to achieve such an objective? But the fact is, today, a call like that, once this law comes into being, a call like that would become a straightforward offense of terrorism. You don't have to go to UAPA or anything. You don't have to go to any special laws. This will become a regular IPC law. Once again, for organized crime, a bunch of new laws have been put in the new Bharatiya Nyaya Sanhita, the new penal code. These then, for the first time, give India specific laws against organized crime. So far, to charge people for organized crime, you had to take resort to special laws enacted by certain states. Makoka, for example, the Maharashtra law, or Gujkoka as it's called, the Gujarat law. Now that will not be needed. The new sections, that is 109 and 110 of Bharatiya Nyaya Sanhita, they now not only list organized crime, but they also define organized crime quite sharply. And they say, for example, if a bunch of people get together and commit a crime, they will all share a similar kind of punishment. So if an organized crime results in somebody's death, then it's punishable with death or life. Otherwise, anything between 5 years to imprisonment. If you are a part of any conspiracy, that's for organized crime, then you can be punished between 5 years to life imprisonment. Also, harboring such a criminal involved in an organized crime, harboring such a criminal is also an offense, which carries a sentence of between 3 years to life imprisonment. Of course, a separate dispensation has been made for petty organized crime. For example, like in old days, people used to do black marketing of tickets outside cinema halls. Similarly, theft through shoplifting, card skimming, ATM thefts, etc. People work in gangs. People run gangs of 100, 200, 300 and carry out these operations in concert. Those have been put specifically under section 110, and those have lesser sentences than the more grievous offences done in an organized manner. Again, 101 subclause 2, the new section, very important section. When a group of 5 or more persons acting in concert commit murder, this is the section for hate crime or mob lynching. So give it the headline, hate crime / mob lynching, because there is often been a demand for a specific law against hate crime or mob lynching. This is that law. Section 101 subclause 2. When a group of 5 or more persons acting in concert commits murder on grounds of race, caste, community, that's religion, sex, place of birth, language, personal belief, or any other ground, each member of such a group will be punished with death or life imprisonment or a term which shall not be less than 7 years. So in this case, not the person who actually pulled the trigger and not the person who actually stabbed the victim or who delivered the killer blow with the lathi on the victim. It is all the people who are acting together. So if it's a mob of 200 people, all 200 will be subject to the same punishment. That's why it's a mob lynching law. It's also a hate crime law. It's very important. I know that there'll be much debate on this, but this is a very important law. Now, offences against women, they've been categorized in a separate chapter. So one good thing that this new formulation has done is they have consolidated many of the laws, because the earlier code was scattered. It was scattered. Now, crimes against women are in one section, crime against children are in one section, assault are in one section, kidnapping in one section. Many of these laws have been made gender neutral. For example, trafficking a person for use in sex trade or for illicit sexual activity, illicit sexual intercourse. Earlier, that protected only women. Now it protects men as well. I'm talking about juveniles, those below the age of 18. So earlier 2 offenses, that is assault or use of criminal force on a woman with the intent to disrobe, to take her clothes off, or voyeurism. It has been made gender neutral, because earlier only a man could be accused of this crime. Now even a woman could be accused of this crime. The victim, however, will be still only female. Now there are a couple of other very interesting changes vis-a-vis crimes against women. For example, new provision has been added for sexual intercourse by employing deceitful means. Now, there are a lot of cases where the complaint is, so-and-so had promised to marry me and was having sex with me for 7 years or 8 years, but did not marry me, so I've been raped all this while. Now, this has been finessed under the new law. It says that this will be an offense only if deceitful means were employed. I will try and explain this to you. This is the new section 69 in the new law. It says, whoever by deceitful means or making promise to marry a woman without any intention of fulfilling the same and has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape shall be punished with imprisonment, etc., etc., etc. Then it gives an explanation. And the explanation says, deceitful means shall include the false promise of employment or promotion, inducement or, listen to me carefully, inducement or marrying after suppressing identity. This is not what might be called, I'm sorry to be facetious, this is not what might be called on the basis of pyar mein dhoka situation. This is on the basis of when a person pretends to be someone else, or a person says, I am not married, but the person is married. Or when the person says, I am from this faith, but is from another faith, that I am now interpreting this. Then it becomes a deceitful promise leading to sexual intercourse, which becomes a punishable offense. So this brings more clarity to such cases. Now, 2 very interesting reforms that I've noticed, and I've asked Bhadra also to check, and she also thinks that we've actually made the right discoveries. That is the law, the terrible law that we had earlier, section 309 of IPC, that is attempt to commit suicide. If somebody tried to kill themselves by suicide, and failed or did not succeed in killing themselves. Think of the irony. Then they were subject to criminal law, which means they could then be charged by the police with the crime of trying to kill themselves, and that law carried a jail sentence of 1 year. So here is a person who's in such a bad state of mind, such a desperate state of mind, that the person unfortunately decides to end their life, and then fortunately they don't succeed. Fortunately, they fail, the life is saved, but then they have to deal with the police case, courts, etc., etc. It seems to us so far, on our reading so far, that law has been abolished. So the attempt to die by suicide has been decriminalized. If so, this is a major reform. Second, what used to be section 377 of the IPC, unnatural offences, homosexuality, etc., that's completely gone. That has not been replaced with anything else. So section 309, that is attempt to commit suicide, and 377, that is unnatural offences. The section on adultery, all of these seem to have gone in the new law. And finally, two very interesting things. One, the law of defamation. Law of defamation, community service has been added as a punishment. So while imprisonment for criminal defamation and fine will remain on the books, community service has now been added. That's an innovation, because that's not usually done under the Indian legal system. And finally, one important reform, at least in my reading, is the new offense, the definition of a new offense of escaping the scene of crime after committing a rash and negligent act, not amounting to culpable homicide. So, किसी को टक्कर लग गई, आप भाग गए वहां से, right? So, if you are caught later, you are only chargeable with the gravity of the crime, that maybe somebody lost a limb, maybe somebody's property was damaged. In this case, if you now escape, not you, if anybody now escapes a scene of crime like that after having committed a crime through rashness or negligence, that itself will become an offense. So that then takes you back to all the rash and negligent driving deaths and injury cases that we've seen, in which really influential and powerful people have been involved. They've fled from the scene and finally got away quite lightly. That loophole has now been plugged. Now there's a lot more to read in the IPC itself, in the new IPC, that is the Bharatiya Nyaya Sanhita itself, and also the new CrPC and new Evidence Act, that is the Bharatiya Nagarik Suraksha Sanhita and Bharatiya Sakshya Bill. We'll read those in the course of time and come back to you with more analysis.